Hello, guys. Welcome to another session. So, do you know what actually gives an ordinary citizen the power to stand up against any kind of injustice or question the mighty and uphold equality? It's not just the vote that you cast, or it's not about the flag. It's actually the Constitution of India. And today, what we do is we begin with a powerful journey into the soul of our Constitution. And in the next 20 lectures, we'll try to complete the essence of Constitution, which will definitely help you not only for UPSC, or even if you simply want to understand how India functions as a republic, this is going to help you. So we are diving into the basics that actually govern your rights, your duties, and the institutions that actually hold this country together. So stay focused and watch the 20 lectures. You'll get complete understanding about the fundamentals of Indian polity. Let's start with the structure of governance. Let's try to understand legislature, executive, and judiciary first. See, in India, governance rests on three primary pillars. So what are they? The legislature, executive, and the judiciary. So what the purpose or the role of legislature? Legislature make laws and the executive implement them and judiciary enforce them. Okay, so see, when we talk about due process of law or procedure established by law, when we talk about procedure established by law, here the legislature make a law, the intent is not checked, but whether the executive implemented it properly or not is what you check in procedure established by law. That's what we followed before, and then Maneka Gandhi case we came across the due process of law, which means the intent of the legislature. The law need to be good first. So that means the legislature, the law also need to be checked. The implementation also need to be checked. The law need to be good. The implementation also need to be good. Nothing, both of these cannot be bad. And judiciary enforce them. So legislature make the law. The intent of the law should be good, and the executive implement the law. The implementation should be as per the procedure which is established before the law, and then the judiciary enforce it. If any of this is not correct, if the law is bad, it can struck down. If the implementation is not as per the law, it can struck down. So again, unlike the presidential system like the US, in India we have executive. The council, executive means the council of ministers is actually drawn from the legislature. So in a way, the executive is part of the legislature. So I hope that part is very clear. And in a democracy like ours, ministers are members of parliament, and if not elected already, they must be get elected within 6 months. All these things I'll be discussing in detail in the chapter of parliament. So this close connection make actually the Indian governance unique compared to systems with stricter separation of power. Now, let's try to understand the difference between parliamentary and presidential system, the core of it. Just to make the fundamentals very clear, that's the objective of this lecture, okay? So in the presidential system, the executive is entirely separate and independent of the legislature. So that's completely independent and completely separate with respect to the legislature, and they can't create laws themselves. They rely on the executive. So, for laws, they rely on the legislature. For example, even if the US president wants a law passed, so the Congress can oppose it. But in India, that's not the case. If the executive enjoys majority support in the legislature, it can easily pass the law. They themselves can implement the law that they have passed. But what you need is majority. So the Indian executive can often influence the legislature if they have the majority. And that makes governance more efficient, though, of course, without, you cannot say it is without risk. There are risks involved, right? Because they are the ones who are going to implement. So if they enjoy majority, whatever they laws they want, they can make it. That's something which is there. That could be a negative also. Now, why separation of power matters? See, separation of power basically ensure that no single organ of the government becomes too powerful, like not legislature, not executive or judiciary. So they have the clear, distinct responsibility. So the powers are separated. In India, this separation basically exists, but not as rigid as in US. I told you in US, executive and legislature is totally separate and independent, but that's not the case in India. That's something which we have already discussed. Now, why this is important? Because why separation is required is because it prevents arbitrary action. Executive cannot implement or take any such arbitrary action if the law is not there. So if the law is there, the role of the executive is to implement, that. So the judiciary again plays a very key role in keeping the executive as well as legislature in check. So judiciary will check whether the law is correct or good or with a good intent. And judiciary will also check whether the law is implemented by the executive as per the procedure. So ministers, again, who are part of the executive, they must be MPs and are accountable to the legislature. So you can see a clear overlap, and this overlap actually defines the Indian parliamentary system. So I hope you got that difference. I hope you got the understanding of why the separation of power is important in this context. Now, let's try to understand. There are two types of executive: political and permanent executive. So, political executive means we can say temporary; they get elected. Permanent also the officers. Okay, so the bureaucrats. So the political executives are ministers who belong to political party and they stay in the office for that limited term. Usually, it's for 5 years. So they get elected, they comes into that ministership, and then they enjoy that power. Permanent executives are the bureaucrats like IAS officers, IPS officers, and they serve till the retirement. So these are what I mean by permanent. So two types of executive: political, they are temporary, and then the permanent executive, that's the bureaucrat. So the political executives, they take the decisions, and the permanent executives advise the temporary executives or the political executives and implement them. Okay, so the officers are going to implement that, and together, both of them together, they form the administrative backbone of the country and the core of that governance. Now let's try to also understand this term constitutionalism. So what is constitutionalism? See, when we talk about constitutionalism, it's the idea that the government should operate within a framework of rules and laws, which is called the constitution. Rules and laws. Okay, so within that only the government should operate. So, at its heart, if you see, it lies the principle of rule of law. So, rule of law is what we need to discuss when we talk about constitutionalism, which means no one is above the law, not even the prime minister. So, when I say rule of law, it's ultimately the law what matters. No one is above the law, not even the prime minister. Law is the king, not the king as the law. That's something which we need to make it very clear. Law is the king, not the king as the law. So no one is above the law, and not even the prime minister of the country. So the other elements supporting constitutionalism, if you see, that definitely include democracy, right? Separation of powers, judiciary, fundamentalism, fundamental rights, sorry. So all these are part of constitutionalism. So again, judiciary assures or ensures that the citizens are not subjected to any arbitrary government action. Okay, so the role of judiciary is very clear now. The role of legislature is clear. The role of executive is clear. Now, what is rule of law and how it is implemented? The rule of law, as explained by A.V. Dicey, which means no one can be punished unless they violate a law. So a punishment can be there only if they violate the law, and whether someone has violated the law must be proved in a court of law. So this is what simply mean by rule of law as per the explanation given by A.V. Dicey. So no one can be punished unless they violate a law, and whether someone has violated a law must be proved in a court of law. So this basically protect people, you, me, and everyone from the arbitrary arrest, and also ensures justice. Also, a person cannot be punished for an act that was not illegal at the time they did it, right? That means what? So that's why ex post facto laws are not allowed. I'm not talking about civil cases or any taxation related cases. That's where that cases will come. But here I'm talking about criminal cases. Okay, so the idea was first introduced in India by Lord Cornwallis during the British era. So we have discussed about this when we discussed in history, right? What Cornwallis did and all those judicial reforms. In that, we had done a detailed discussion on his reforms. Okay, now, coming to federalism and its origins in India. See, we follow what structure? We follow a quasi-federal structure, federal in form, but unitary in spirit. That's how we understand our structure. So, we follow a quasi-federal structure, which means federal in form and essence, but unitary in that spirit. So, in a federation, power is divided between two levels, center at the state top and states. So, power is divided between two levels, center and states, but both derive power from the constitution and are independent in their own spheres. So the state have their power, center have their power. Both are independent in terms of that because both derive power from the constitution. We have a written constitution and we also have an independent judiciary to resolve any disputes between center and the state. But again, if you see USA, Now, unlike USA, what we can see is in India, we allow some overlap and central dominance, especially like when we talk about emergencies. So during that period, definitely center dominate. Now, let's try to focus more into this federal and unitary features. See, when we talk about federal features, these include clear division of powers, like we can see in our constitution, union list is there, state list is there, and then concurrent list is there, which you can see in the Schedule 7. And states and the center have their own area of legislation, which makes it very clear that it's federal. These are federal features. But again, if you look at articles like 249, 250, 252, 253, they show the kind of unitary bias. I'll be discussing this when I talk about Rajya Sabha or when I talk about the chapter of parliament. Again, for example, if I want to give Article 249, that Rajya Sabha can allow the parliament to legislate on state subject, and under 250, during national emergency, parliament gain that power to legislate on state matters also. So you can see there is a tilt towards center that makes Indian federalism a kind of unique. Okay, so here again you can see, though we are, in essence and spirit and everywhere, federalism is there, the features are there, but still, at times, center dominates. Okay, let's talk about this objective resolution. Okay, see the objective resolution, because we are now moving on to constitution, so we are now going to start. So the objective resolution was introduced by Nehru in 1946 and passed in 1947. So this actually outlined the core philosophy of our constitution, which talk about sovereignty, which talk about democracy, secularism, justice, and all these are the features of our constitution, or the philosophy of constitution, which is mentioned. And our constitution, as you know, that's borrowed from many countries, and of course borrowed several features from this also. So now they can ask you questions like the features which is borrowed from other countries. For example, we have borrowed fundamental rights from USA, DPSP from Ireland. Guys, all this again, I'm going for a quick recap and revision. So I hope that these are areas that you have already covered, and these are very basic things that you are supposed to cover. So fundamental rights USA, go for quick recap of that. Remember that in case if you get a statement question, you should be in a position to clear it. So DPSP is from Ireland, and then the parliamentary system from UK, and the federal structure from Government of India Act, of course, that's Government of India Act 1935. There are many features which is borrowed from 1935 Government of India Act. So you need to understand these borrowed features. This will actually help you to appreciate the blend that the constitution have, or the mix and matches with other countries also. So how we are unique also, you will understand, because you can see all the good features from different countries have been borrowed. Fundamental rights from US, DPSP from Ireland, the parliamentary system from UK. The good things have been taken, and we have a mix and match. That's why our constitution is a unique and something which you need to remember for your exam purposes. Okay. Now let's talk about written and unwritten constitution, and also the importance of preamble. Regarding preamble, I have discussed yesterday. And when we actually start our polity sessions, I'll give more emphasis on that first lecture with respect to preamble. So there in detail we'll discuss. So if you see, India have a written constitution, which means everything is codified, clearly written, right? So if you see UK, it's a evolving system. Our constitution is supreme, and any law that contradicts the constitution will struck down. For example, any law which violates the fundamental right, it will be struck down. It's void, right? So the preamble is not enforceable. That reflects the constitution's philosophy. So when we talk about preamble, you'll see justice, liberty, equality, fraternity, and all those things. That's in fact forms the basic structure of the constitution. Also later, when we talk about Keshwananda Bharati case, all these will be discussed in detail. So preamble also will capture the basic structure like justice, liberty, equality, fraternity. These are not this judicial review, fundamental rights. All these will come. But again, some of the words here, secularism, all these are basic features. So you'll get an idea about the constitution from the preamble itself. So what is constitution in one word is what the preamble. And Supreme Court actually refers to it when the interpretation of constitution is going on. And it was declared, as part of the constitution in the Keshwananda Bharati case, and it can be amended. And you can see in the 42nd Amendment, socialist, secular, and integrity were added. So the preamble can be amended. It's part of the constitution. So it has been acknowledged in the Keshwananda Bharati case. So these are the basic things that I wanted to cover here before we actually start our lecture. So Remember this, the Constitution is not just a book of rules, it's a contract between you and the state. It empowers you, protects you, and guides how the nation functions. And you need to understand the basics of legislature, executive, judiciary, rule of law, federalism. That's exactly what actually the purpose of this session. So I hope you are very clear with legislature and executive, also judiciary, how the separation of power work, how judiciary checks on legislature and executive action, and how rule of law functions, and how federalism work, and all these things. I hope you have a clear idea. So again, we'll continue this journey in the next session. So revise the concepts, and always remember, knowledge of the Constitution is knowledge of your power. Your power derived from Constitution. So see you guys in the next session. Thank you so much for watching. I hope you got some idea. Thank you so much.